Well, good morning, everyone, or afternoon, depending on where you're at. Welcome to the next chapter in the Fidelis National Webinar Series about compliance. My name is Brad Woolard. I'm one of the sales directors here at Fidelis. Also with me today is going to be Mitch Anderson, our Director of Operations. We also have Miss Bernadette Russo, who's our Senior Sales Director. We've got Kara DeVore, another Sales Director, Marisa Canold, and another sales director. And is Nick on? I don't know if Nick's on today, but Nick's also another one of our sales directors here at Fidelis. So again, I just want to thank you all for taking the time today to jump on this webinar, learn a little bit more about the exciting world of compliance. And for the next 3 hours, we're going to delve deep into compliance. I'm just kidding. Actually, I believe we've got this knocked down to about 45, 50 minutes, so we should have enough time at the end for questions. Now, everyone is muted. If you do have questions, we do have a chat box that will be monitored by the sales directors as well as Mackenzie. She's one of our compliance officers. And if it's something we can answer right away, we will. If not, we will ask you to go ahead and email those questions over to our compliance department so we can get that information to you as quickly as possible. And one little disclaimer before we get started, this is compliance training as of 7/31/24, because we know that compliance never changes and it will always stay the same, which is not true. So anyway, with that, Mitch, do you have anything you want to say? Should we just...
Yeah, we have a ton of content that we're going to be going over today. Thank you for introducing everyone, Brad. So we're going to be going through quite a bit here, and if there is any questions, feel free to ask them in the chat. We have multiple people on our team willing to answer these questions. If they become a complex question, we just ask that you email it to our compliance inbox, which they will put in the chat, and we can get back to you with the answer that you're looking for. So without further ado, I'll go ahead and get us started here.
All right.
So this is going to be our agenda today. We're going to go through Medicare products, FDRs and TPMOs, Medicare plan regulations, agent compensation and administrative payments, enrollment periods, permission to contact, events with beneficiaries, call recording, anti-kickback statute, agent do's and don'ts, communication and marketing guidelines, and disclaimers. So as you can see, we have quite a bit to go over. And then also submitting marketing materials. So Brad, if you want to get us started here with the Medicare products.
Yeah, let's talk about Medicare products. So as you may or may not know, because I know we do have some new folks on, and probably a refresher for those that have been doing this longer than a month. We have a couple different ones. And of course, we have Medicare supplement plans, AKA the Medigap. Those are federal government sets the minimum standards for those. States generally are responsible for regulation and enforcement. And then we have the Medicare Advantage, also known as Part C, and prescription drug plans, Part D. Those are regulated by federal government or the CMS. CMS is responsible for regulation and enforcement. On the Medicare supplement plan, AKA Medigap, again, those are standardized plans, A through N, offered by private insurance companies, pays for the gaps of covered services after original Medicare pays 80%. Doesn't include prescription drug coverage, but that is available to buy on a standalone plan. Medicare Advantage, also known as Part C. Those are HMOs, PPOs, special needs. Again, offered by private insurance companies, combines original Medicare A and B, and often prescription drugs, which is the Part D, into one plan. And many plans include additional benefits like dental, vision, hearing, fitness, OTC, etc. And of course, we have prescription drug plans, Part D. It's offered by private insurance companies, combined with most Medicare Advantage plans, and offered as a standalone plan as well. And I kick it back over to Mitch.
Yeah, so FDRs and TPMOs, let's learn a little bit about them. So CMS holds the Medicare Advantage and PDP plans ultimately responsible for compliance with the Medicare laws and regulations. Medicare Advantage and PDP plans contractually obligate the parties and that provide services to on their behalf to also comply with Medicare laws and regulations and implement compliance mechanicisms. These downline entities are referred to as first tier, downstream, and related entities. That is what an FDR is. So first tier entity has a written arrangement with a plan to provide administrative or health care services. Downstream entities have written agreements below the first tier entity, continuing down to the ultimate provider of the administrative services, which could be sales, marketing, enrollments, and then related entities, which are NMOs, FMOs, brokerages, agencies, agents, and brokers are all FDRs because they are first tier or downstream related entities that provide sales, marketing, and enrollment functions for the Medicare eligible individuals on behalf of the plans. Little comment here, agents and brokers, they are all FDRs. Third-party marketing organizations, also known as TPMOs, are organizations or individuals, including independent agents and brokers, who are compensated to provide any of the following services as part of a chain of enrollment. This can be lead generation, marketing, sales, and enrollment-related functions. Lead vendors and other vendors or subcontractors who are compensated to perform lead generation or marketing for a plan or for a first tier, downstream, or related entity are also TPMOs. You are an FDR. Therefore, the following are also TPMOs, your lead vendors, your other vendors, contractors, and subcontractors that are compensated to perform lead generation, marketing, sales, and enrollment-related functions as part of the chain of enrollment. Specific requirements apply to all TPMOs. Contracts between Medicare Advantage, PDP plans, and TPMOs and contracts between first FDRs and TPMOs must impose certain requirements on TPMOs. Before we go over that, why that is important is because each level from the carrier and CMS down regulates the next level down. And so that's why at Fidelis, we in our compliance team are working with the agencies and the agents individually to make sure that everything is compliant. If there is a compliant violation, we want to work with everyone to ensure that we're working through the process in the way that the carrier and CMS is requiring us to do so.
Thanks,
Back over to
Mitch.
Brad here.
All right, Medicare plan regulation. So Medicare Advantage versus Medicare subplans, requirements imposed by federal and state regulators. Medicare Advantage, Medicare approved plans from a private company that offers an alternative to original Medicare. These plans usually include Part A, B, D coverage. And then Medicare sub plan sold by private company that fills the gaps in original Medicare. Medicare Advantage and Part D plans regulated by the federal government through CMS. Plans are required to comply with the CMS regulations set forth in that number. Plans must also include certain requirements and contracts with first-tier downstreams or related entities and contractors, subcontractors. And Medicare subplans, again, federal government sets minimum standards. States generally are responsible for the regulation and enforcement. State agencies governing insurances set the requirements for plans and carriers. And of course, there are variations in Medicare subplans. And now for the fun part.
Agent compensation and administrative payments. So when it comes to Medicare subplans, they're set by the carriers, varies by beneficiary, location, carrier, and policy. There is no maximum commission schedule. Initial year equals percentage of premiums. Renewal year equals smaller percentage of premiums. Paid as earned or may pay in advance depending on the carrier, and commission payments not disclosed. When it comes to Medicare Advantage and PDP plans, These are set by the carriers. CMS establishes maximum commission schedule annually. Initial year equals a flat payment per sale up to CMS maximum allowed. Renewal year is equal to CMS maximum allowance of 50% of the initial year max. Can be a lump sum paid up front, and CMS publishes maximum payment schedules annually. So with Medicare Advantage and Part D, carriers may only pay ready-to-sell agents who, 1, are licensed and appointed under state law, 2, are trained and tested annually with a score of 85% or higher, and 3, secure and document a scope of appointment prior to meeting with potential enrollees. So here is the 2025 CMS initial year with the renewal year attached. So national is 626 with a renewal of 313 for different states that have higher premium or higher payout. You can see here. And then for Part D, we are at 109 and 55. So 109 on the initial, 55 on the renewal years. Carriers may pay renewal year compensation in any year following the initial enrollment year that the beneficiary remains in the same plan, or when a beneficiary enrolls in a new like plan type. Carriers must pay prorated initial enrollment year compensation if a beneficiary's plan changes during their initial enrollment year or a beneficiary selection of an unlike plan type change. In this case, the new plan would only pay the months that the beneficiary is enrolled, and the previous plan would recoup the months that the beneficiary was not in the plan. Carriers must recoup payments when 1, a beneficiary changes plans within the first 3 months of enrollment, also known as a rapid disenrollment, and that is the entire amount is recouped. Any other type of beneficiary, or secondary here, any other type, a beneficiary is not enrolled in a plan, but the plan paid compensation based on that time period. Plan must recover prorated amount equal to the number of months not enrolled of an initial enrollment year or renewal year compensation. These are paid by the carrier to agencies and uplines for administrative and operational services provided to support the agent. Payments must not exceed the value of those services in the marketplace, meaning they cannot go above the maximum allowance. Payments must be based on enrollment. All right, Brad, tell us about enrollment periods.
Well, this is what we all want to know. How do we get these folks enrolled? So, of course, we have the initial enrollment period. Again, 7-month window. It's around their 65th birthday. They get 3 months before their birth month and 3 months after. And then I don't know if anyone knows, but we have something coming up now. I think it's called AEP, October 15th through December 7th. And that's when marketing can begin on 10/1, but no applications can be taken until 10/15. And then as we know, we have open enrollment period. That's January 1st to the 31st. Those on an MA plan can switch to a different MA plan or go back to original Medicare. We have one more, special enrollment periods. It's event-based enrollment periods for special circumstances, such as you've moved outside your plan service area, you lose your current coverage, plan changes, it's contract with Medicare, switching to a 5-star rated plan, or other special situations. Again, we have several of the Fidelis sales directors on here. You can go to our website and check the maps for what we service. And if you have questions about SEPs in that state, that's something we'd be more than happy to help you out with. So, all right. Medigap open enrollment. Again, that's 6-month enrollment period that starts first day of the month. You turn 65 as long as you signed up for Medicare Part B. If you have delay enrolling in Part B and have credible coverage, your 6-month enrollment period begins when you enroll in Part B.
All right, so permission to contact. This is something that we get plenty of questions on, so we thought we'd add some slides here to kind of clear some questions up. So for Medicare Advantage and Part D, permission to contact, a valid permission to contact can be with a completed scope of appointment, consent language on a lead form, or a business reply call. And these must be retained for 10 years in the beneficiaries file that you keep. All right. You must have a valid permission to contact with your name or one of your upline agency's names to call, text, direct message, leave a voicemail, or contact in any way. You are not allowed to cold call, and no unsolicited direct messaging, including social media. Exception, calling a client about planned business. You may not market prior to October 1st under the pretext of planned business, meaning that you are able to contact a client about planned business after October 1st. You may not make unsolicited calls about other lines of business as a means of generating leads for Medicare plans. You may not solicit door-to-door. You may not approach enrollees in common areas. You do not need permission to send unsolicited emails to beneficiaries. You must include an opt-out function, though, in those emails if you are doing email campaigns. And you do not need permission to send direct mail to beneficiaries, meaning you can send mail out to an area. You do not need a permission to contact on that. All right, Brad, tell us about events with the beneficiaries.
I'd love to, Mitch. I'm glad you asked. So we have a couple different ways we set up events for beneficiaries. Obviously, we have the educational event, and that must be advertised as educational. It cannot be market specific for MA plans or benefits. It may obtain beneficiary contact. You may be able to obtain beneficiary contact info and a scope of appointment. And you may also set up future personal marketing appointments, and you may provide meals. Now, if you have a sales event, sales seminars, you may not provide meals, but you may provide snacks and refreshments. You may not require sign-in. You may not require contact information as a prerequisite for attendance. And you may not call attendees unless they give you express permission.
That would be a business reply card. Those are allowed, but continue.
And then, of course, we have our personal appointments. As we should know by now, you must obtain your scope of appointment prior to the meeting. Must obtain an additional scope before discussing additional health-related products, not on the existing scope of appointment. And you may not market non-health related products. And then, of course, we have the scope of appointment, which is required for MA and Part D plans, required prior to the appointment, required for all one-on-one personal marketing appointments. It's required regardless of the venue, whether it's in person, telephonic, walk-in, virtual. You got to have one. Must be either hard signed copy or electronic or telephonic. Recording only for telephonic appointments. And must include all product types to be discussed. Must include the date of appointment, beneficiary contact info, agent info, no obligation to enroll disclaimer, as well as Medicare enrollment status not impacted, and automatic enrollment will not occur. And yes, you must retain these for 10 years. Compliance. Mitch, tell us about call recording.
All right, on to call recording here. So with call recording, all TPMOs, including agents and brokers, must record all chain of enrollment calls with beneficiaries in their entirety. We personally recommend that you just record all calls because there's not a reason to not. And then that way, if you ever are caught in a situation where you're needing to deal with compliance, you have multiple call recordings speaking with the beneficiary. Also, Medicare Center has free call recording capabilities, so keep that in mind. Anti-kickback status. Okay, so the anti-kickback status is a federal statute that applies to federal healthcare programs, Medicare Advantage, Medicare Part D, Original Medicare Parts A and B. Medicare Supplement is not a federal healthcare program. All right, the anti-kickback statute prohibits knowingly and willfully paying or receiving an remuneral to induce a referral for items and services that are paid for by federal health care programs or to induce the arranging for the furnishing of items and services that are to be paid for by federal health care programs. Felony criminal statute punishable by $100,000 per violation and up to 10 years in prison also can be the basis for a False Claim Act violation, which is subject to additional penalties. Best practices for giving gifts. That is what this is directly referring to, just so everyone is aware. So you never want to give cash equivalents, or monetary rebates to beneficiaries. Do not offer gifts to beneficiaries. There is the exception of nominal gifts that are offered to similarly situated beneficiaries without discrimination, without regard to whether or not the beneficiary enrolls, not in the form of cash or cash equivalent or a monetary rebate. What is defined right now as nominal is $15 or less per gift and an aggregate of $75 per person per year. So if you are meeting with someone more than 5 times, you cannot give them a $15 gift each time. Cash equivalents, including gift cards, except for limited items or food, gas, and coffee. Best practices for providing meals to beneficiaries. Educational events. Meals are permitted at educational events. They should be nominal in value though, meaning $15 or less. At sales events, do not provide meals regardless of value. Refreshments and light snacks are permissible. And of course, CMS has some wording in there about having multiple snack items that may be bundled to make a meal. That is not allowed. Best practices with referral sources. Follow CMS marketing rules and guidelines. Do not give gifts or payments to referral sources subject to a limited exception. Do not split commissions or renewal commissions with referral sources. Do not accept gifts or payments for referring individuals to healthcare providers. Key takeaway here, if you are in doubt, ask our compliance team. We are more than happy to tell you if you are or not allowed to do something. All right, Brad, tell us about the agent do's, and I will tell them about the don'ts.
Would love to. That's why I'm glad you and I are doing this. So we have a sales director in the sales part, and then we have the compliance guy that helps keep us salespeople on track. Because I don't know if you're like me, I like to listen to people that keep me out of trouble. That's usually compliance and attorneys. And so I'm glad we're both on here together. So now I can tell you the do's. And an agent may call a beneficiary who has expressly given advanced permission, such as submission of a business reply card or scope of appointment. You may call a beneficiary whom they enrolled in a plan to discuss plan business, as well as discuss the availability of other plan options and types within the same parent organization. And of course, disenrolled beneficiaries may also be called for quality improvement purposes. And you can call or visit beneficiaries who attend a marketing or sales event if prior permission was given and documented. Give me another do. What else can we do? We can initiate a phone call to confirm an appointment. A second scope of appointment must document additional product types if the interested beneficiary that will not agree to in advance. And then you may conduct marketing sales activities in common areas of healthcare settings, common areas. And you may provide refreshments and snacks at marketing and sales events. You may schedule appointments with beneficiaries who live in long-term care facilities and other congregate housing only upon request by the beneficiary.
All right, and
Here comes the hammer. Here comes the hammer.
These are the don'ts. You may not state that you are from Medicare or use words, symbols, including Medicare in a misleading manner. Market to beneficiaries door to door, including leaving materials at a beneficiary's doorstep. Send unsolicited text messages or leave voicemail messages. approach beneficiaries unsolicited, meaning door to door, walking up to cars and approaching in parks and supermarkets. You may also not conduct marketing and sales activities in healthcare settings except for common areas. I know Brad really emphasized that. Common areas is key here. Making unsolicited calls, including contacting beneficiaries under the guise of selling a non-Medicare Advantage or non-prescription drug plan product. Provide material or meals at marketing and sales events, and conduct marketing or sales activities at an educational event, including distributing marketing materials or enrollment forms. Those are all do nots. And then I will talk to us more about communication and marketing guidelines. All right, so I'm not sure how familiar everyone is, but CMS regards things either in the bucket of communications or the bucket of marketing, and each one has its own guidelines. So we're going to go through that today and kind of just talk about what the differences are. Communications are any activity and material used to provide information targeted to current and prospective enrollees, including their caregiver and other decision makers. Examples of communication include generic postcards, business cards, flyers, and brochures. Pre-approved customizable versions of these can be found on our marketing hub. That is on the Fidelis website. So go ahead and check that out. And if you guys have questions or need help, definitely let us know. Okay, on to marketing now. Marketing is any activity and material with the intent to draw a beneficiary's attention to a specific plan or plans and to influence a beneficiary's decision-making process. Marketing includes content about plan benefits, cost sharing, measuring, or ranked standards. Marketing materials need to be submitted to CMS for review and approval, including websites and social media. So definitely keep that in mind. When it comes to intent is defined by CMS as draw a beneficiary's attention to a Medicare Advantage plan or plans, influence a beneficiary's decision-making process, or making a Medicare Advantage plan selection, influence a beneficiary's decision to stay enrolled in a plan. When evaluating intent, CMS will consider objective information such as the audience of the activity or material, other information communicated by the activity or material, the timing of the communication, and other contexts of the activity or the material. When it comes to content, it is being defined as the plan's benefits, benefit structure, premiums or cost sharing, measuring or ranking standards, rewards and incentives. Marketing materials do not need to mention a plan by name to be considered marketing. That's something that you're going to want to keep in mind here. Marketing materials can be ads that are made on behalf of multiple plans also. An example of marketing materials, a billboard reads, Swell Health offers 0 premium plans in Nowhere County. A third-party TV commercial actor says, call us to hear about plans that can provide hearing and dental benefits, $0 monthly premiums, and can even lower your Medicare Part B costs. A marketing postcard that reads, you may be eligible for plans with $2,500 in dental coverage, and postcards that read, call to learn about plans that can get your money back in your Social Security check. These are all examples of something that has to do with marketing. Medicare Advantage organizations must submit all marketing materials, all election forms, and certain design or designated communication materials for CMS review. Materials are to be submitted to the Health Plan Management System, HPMS, and then Medicare Advantage organizations must submit all materials through the module or third parties granted access by a plan to submit materials on the plan's behalf. Materials cannot be used unless CMS has reviewed and approved, deemed approved, or accepted under the file and use rule. All right, now over to some communications. Ensure that communication materials and activities do not provide inaccurate or misleading information. make unsubstantiated statements, engage in misleading or misrepresenting activities, engage in any discriminatory activity, target potential enrollees based on income levels or health statuses, employ Medicare Advantage plan names that suggest the plan is not available to all beneficiaries, display the name or logos of both the co-branded network provides on member ID cards. So these are the communication materials. Activities cannot use a plan name that does not include the plan type. Claim endorsement from CMS, Medicare Secretary, or HHS. Convey that a failure to pay premium will not result in disenrollment. Use the term free to describe a $0 premium or any type of reduction in premium or cost sharing. Imply that the plan operates as a supplement to Medicare. State, imply, or market a plan as available only to dual eligible beneficiaries if it is not. And lastly, claim a relationship with the state Medicaid agency if a contract is not in place. So here are some general marketing rules. The following is prohibited: cross-selling during a Medicare Advantage or PDP sales activity or presentation. Cross-selling is the marketing of non-health care related products, including life, annuities, final expense, and wealth products. Healthcare products that may be cross-sold include Medicare supplement, dental, vision, and hearing, ancillary health products. Comparing plans to other plans unless the information is accurate. Displaying the names or logos or both of provider co-branding partners on marketing materials unless a disclaimer is present. Annual enrollment period. Marketing may not begin for the prospective plan year offering until October 1st. Initial enrollment period may market to beneficiaries aging in who have not yet made an enrollment decision. 5-star plans may market 5-star plans to beneficiaries in the service area unless it is after November 30th and the plan has not received an overall 5-star for the next contract year. So that's something to keep in mind, that by November 30th, the star ratings are renewed. May market to dual eligible and LIS beneficiaries who may make changes once per calendar quarter during the first 9 months of the year. General marketing rules: open enrollment period. Do not knowingly target or send unsolicited marketing materials to any Medicare Advantage enrollee during OEP. Do not send unsolicited marketing materials referencing OEP. An example of that would be like, it's open enrollment period, call today. Do not send unsolicited marketing materials advertising the ability or opportunity to make an additional enrollment change, such as unhappy, want to change your plan. These are all not allowed during the open enrollment period. Okay, so general marketing rules during the open enrollment period: do not specifically target beneficiaries who are in OEP because they made a choice during AEP by purchasing mailing lists or other means of identification. Do not engage or promote agent or broker activities that intend to target the OEP as an opportunity to make further sales. Do not call or otherwise contact former enrollees who have selected a new plan during the AEP. You may conduct marketing focused on other enrollment opportunities, such as T65 for turning 65, the 5-star plans, dual eligible and LIS beneficiaries. You may provide information on OEP at the beneficiary's request, and you may send marketing materials upon proactive request of the beneficiary. All right, Brad, tell us a little bit about some disclaimers here.
It's our favorite, right? Disclaimers.
Yes.
All right. Note, disclaimers are not required on the following material types: banners, banner-like ads, envelopes, outdoor advertising, text messages, social media. Certain statements are required in a call for call scripts and must be read to clients during the enrollment calls. If you're promoting a specific carrier's product in the market, in the marketing piece, You may be required to include additional legal lines or disclaimers as instructed by the carrier. So again, the disclaimer from us, there are disclaimers for everything. So we're going to go over just a few of the examples, and we will upload these to the website. So feel free to browse and go through it. If you see something, if you don't see something that you need, please let us know. I'm sure we have it. And so this is an example of, say, the federal contracting statement disclaimer, the marketing materials by TPMOs disclaimer, the star ratings disclaimers, the accommodations disclaimers, sales meetings disclaimers, drawings, prizes, or free gifts disclaimers, benefits disclaimers, Part B give back, non-government affiliation, the Medicare supplement disclaimers. Told you we have quite a few ready for you all now. And if you don't see one that you need, again, please reach out to us. I'm sure we have it.
Yeah, I just want to piggyback off of that. There is many more disclaimers than what was just shown. Those are just some examples of things that we see every day. If you do have questions on different disclaimers for different pieces, for your website, for a mailer, feel free to reach out to us. So we have our compliance at Fidelis INS inbox. This is where we can review any material that you have questions on regarding disclaimers. If you just want us to do a peer review to see if it is compliant or if there's some wording that needs to be changed. We want to make sure that this resource is available to everyone. So feel free to reach out to this. We're here to answer questions, help you to make the changes that you need to before you send it off to print or before you mail it out or email, whatever it may be. We are here to just help you with a review. We typically have a few day turnaround time, but as we get closer to AEP, we definitely get more busy. So feel free, if you have something right now that you're trying to work on, to email it over to us and we would be happy to review it for you. We would rather spend the time to review it for you and make sure it's compliant than let you go off and send something that ends up not being compliant and then having to work with you on the backside of that. So we definitely want to help you to be as compliant as possible.
All right, thanks, Mitch. With that, I would like to go ahead and open it up for any questions, because I'm sure no one has any questions about compliance and the complexities of this year. So if we don't mind, we can open this up. Are we able to unmute?
I am unsure, Brad. Gabby, are we able to unmute or is it unmuted? And if people have questions, they can ask them now.
Yes, everyone should be able to unmute.
Perfect.
Perfect. Thank you.
Oh, yeah. Sorry, Vicky, I was just opening it up. Yes, it does still apply.
Hi, this is Aaron here.
Hey, Aaron.
I'll ask this question in case anybody else is in the same position. So my primary line of business is property casualty.
Okay.
So I do have a book of business already. Some folks are on Medicare, some folks are aging in. With my marketing efforts, I mean, right now I'm just sharing with them, oh, I'm so excited. I'm going through the Medicare compliance training, and wow, this stuff is really, exciting, is all I'm leaving it at. But I really want to ramp that up, especially before season, because like it just learned, you can't say, hey, it's open enrollment. By the way, I do Medicare.
Yeah, so Aaron, that's a great question. I've worked on a few different PNCs before with this. So you are allowed to do mailers to your current client list to let them know, like educationally, and just inform them that you now work in Medicare, and that is a line of insurance that you work with. You're also allowed to contact them via email or phone because you already have an established relationship with them. But if you have like questions on specific emails or campaigns that you want to do, definitely email that over to us and we can just make sure that it looks right. And given the context that you're in with the pre-existing relationship, it should be pretty simple for us to help you out there.
Awesome. Thank you so much.
Yep.
Hey guys, I had a quick question.
Yeah.
So it was my understanding that after AEP and during open enrollment, we were supposed to reach back out to our clients just to ensure they were happy with the plan that they had chosen, and that everything was going smooth. They didn't have any questions, or if they did, of course, to answer those. But from my understanding, what we went over today, we are not supposed to check back in with those clients. Can you just clarify that?
Yeah, I'm happy to clarify that for you. So you cannot reach out and market to people that you are not already doing business with.
Okay.
That's what it's in regards to. You definitely do want to reach out to your current clients. Essentially, like you can't start sending a bunch of mailers during OEP to say, hey, it's OEP. Like if you're not happy with your plan, reach out to me. But if they are already a current beneficiary working with you, you do want to reach out to them.
Perfect. Okay, that's what I understood. Thank you.
Yeah, of course.
Hey, it's Marisa. Can you hear me?
Yep.
Hi. Yep, Lisa, I just responded to you, but Mitch nailed it. And then Vicky had the question about the 48-hour rule that I just wanted to add one thing. If anybody is using Medicare Center, just be mindful that it used to do this in the past. I'll double check, but sometimes it'll default to a 48-hour lockout window on Medicare Center when you're sending a scope. So if you have a walk-in client or a situation that waives that 48-hour window, before sending a scope, you want to uncheck the 48-hour lockout window box that populates on Medicare Center. Otherwise, it'll not allow you to enroll that client for 48 hours.
Yeah, correct. And that applies to inbound calls. So if someone calls you, and that also applies to walk-ins. If someone walks into your office and they're like, hey, I'm interested in a plan, that you can do the scope of appointment there in person and start the chain of enrollment. So if you are doing it through Medicare Center, like Marisa said, you're going to want to make sure to uncheck that 48-hour.
And this is Bernadette. I also wanted to add in that if you're working in a retail location, so if you're at a kiosk at Walmart or King Soopers or Fry's or wherever, that is considered a walk-in. So you do not have to worry about the 48-hour rule and you can just do the scope right there.
Yep.
All right, I love it. Love all the tidbits, especially on Medicare Center. That would drive people mad, that's for sure. So thanks for that, Marisa.
You bet.
All right, anyone else have any other questions? If not, I'm gonna give you back 15 minutes of your day. We try to get it in about 45 minutes for y'all. So
Yeah, I just wanted to add something, Brad. I probably shouldn't say anything about this yet, but we are working to update some compliance resources onto our website as well. So we'll be communicating out once we have those up. This isn't an overnight thing, so we definitely need to make sure that we have everything set up to do that, but we want to give you all the resources as well. So we're looking to get those added to the website, and our sales and marketing team will be reaching out to everyone to let them know when they are up there.
absolutely appreciate that, Mitch. And again, thank you to everyone for taking the time out of your day today. We appreciate all that you all do, and we look forward to very successful AEP this year. So thank you all again. We appreciate you